Good morning, Rangana and Dilshani. Can you hear me?
Yes.
Right. So I will start at 8:45, another 2 minutes time, because the others have not joined yet. Rangana, how you feel? You are okay with the lectures that we so far conducted? You're studying, right?
Yes, sir. If possible, can you share some past papers on this subject so that we can go through and just to get an idea on the exams? Like,
Right. Okay. So that I will discuss with the institution whether if they are okay to share the past papers. I have no objection. I can, I can share that. I will discuss that with the institution.
okay, okay,
And
thank
the
you.
other thing is basically the areas that I question, or the high potential areas that I normally inform beforehand to the students, so then you can get ready. I can't say the exact question, but I can inform you the relevant areas, potential areas, which is more potential for the exam. So then you can study those areas uh, and get ready. And the unfortunate situation is, even though I have mentioned previously the potential areas, some students, they have not studied. I don't know the reason, or sometimes I feel that uh, they have not developed the skill of writing answers to a law paper. But some students, of course, they are very good. They scored full marks. So then there can't be a situation like that. Some people scoring very well and some are very poor. So because all the lectures that you follow are the same lecture, no. So therefore, it's all about the preparation. The preparation for the exam. So uh, my advice is always you have to answer. You have to write answers for the questions and develop your skills. For that, of course, I know that you need past papers. That I will discuss with the institution, and if they are okay, then I will share at least one or two past papers. Then you can get an idea. So what sort of questions that comes, and what kind of answer is expected, answers are expected from you. So then you can write answers and practice and develop your skills. That's I Yeah, that's the idea. So I will look into that. Thank you, Rangana, for that concern. Any concern from Dilshani?
So it's the same thing. Some even if you can give us like a model question and a model answer would be helpful, I think. Even in point form, like how to write. I don't think most of us have like done legal before law papers.
Right.
Yeah, if you can give us the idea like how to answer a question, like take one question and like how you should be writing. Is it in like essay form?
Okay, so then in that case, first I will. Uh, I have to discuss with the institution. If they are okay, then we'll
Yeah.
share the past paper. Then at the end of this program, we'll have a revision class on that day, that we will discuss the questions and answers.
Yeah,
What do you
that
think?
would. Yeah, that would be helpful, sir.
Okay, right.
Yeah, the lectures are okay. And it's interesting and like information is enough. Like what you teach is good.
Right. So that you can follow the no issues to follow the lectures.
No, no, it's all good.
Right. Okay. Thank you very much. So now I think we have to start now, because now it's time 8:47. I have to finish a little bit early today because I have some personal matter to attend. Okay, Gavin also join. So we'll start. We have to start from. Sorry. here, I think we last week we stopped at this point. We were discussing about the debt recovery process, and under that we said since the regular process, litigation process is very slow and cumbersome, expensive process. So therefore, we need, as a bankers and lending institutions, we need a speedy, effective debt recovery process. So otherwise, we can't survive in this business. If we have to spend 5 years or 6 years in courts to recover our debts, the debts from the defaulter. So then, in 1990s, the legislature introduced some speedy, effective recovery process. Or in other words, they introduced some acts, laws to the country, which applicable to the financial institutions, and some are especially for the banks, to recover the debts from the borrowers. Those mechanisms, compared to the regular procedure, is speedy and effective. So basically, for this program, that we have to study 2 special debt recovery processes or debt recovery laws. Those are, number 1 is debt recovery. Number 2 of 1999, Act number 2 of 1990, Debt Recovery Special Provisions Act. So this is one of the area that you get a question, right? This one, special laws of debt recovery. So there are 2 laws that you have to study: 2 of 1990, Debt Recovery Special Provisions Act, and the second one is number 4 of 1990, Parata Act. So definitely there will be a question. So I'll say definitely there will be a question. So now you know that you will get a question. So therefore you have to get ready. You have to read little bit more. You have to do some researches and get ready for the question, right? So, and basically this is a straightforward question when it comes to debt recovery, right? It's not difficult like contract law or sources of law, something like that, because when you go to sources of law and contract law, it's a huge area where you have to do a lot of readings, you have to do a lot of researches. There are so many cases that you have to remember. But when it comes to debt recovery special procedure or special laws, there are only 2 laws that you have to study and limited number of cases that you have to remember. And the process is very clear. That is it is a settled process. So if you remember the steps of each process, that you will be able to score full marks. So easy, very easy question to get full marks. In fact, my previous experience is the student, when you compare the questions, this is one of the questions that they have scored very well. So you also will be able to score the maximum. But again, I'm telling you that you have to read and remember the process and the relevant cases and laws, right? Okay, so first one that we are going to discuss is number 2 of 1990. This is known as Debt Recovery Special Provisions Act. So as I told you before, this law was introduced in 1990 year. This is the second act passed by the parliament in 1990. So that is why it is named as number 2, Act number 2 of 1990. The name of the act is Debt Recovery within bracket Special Provisions Act. That you have to remember the number of the act and as well as the name correctly, right? So if you get a question from this area, don't write like DR Act, right? DR Act, if you can't remember that, okay, that you will get some marks, but as a senior bankers and also who have followed the lectures, you can't just write the answer like that. It is always, I advise, write the correct number and the name of the act. So Act number 2 of 1990, Debt Recovery within bracket Special Provisions Act. Why Special Provisions Act? Why it is called Special Provisions Act? Special Provisions Act means that law that gives a special procedure, special provisions, because there is a procedure already established. By introducing this act or this law, the legislature introduced a new method or new procedure or new law, while the other process or other law is existing. This is not a repealing of a existing law. So basically, you don't cancel the previous law and introduce new one. This is an additional law introduced while the previous one is existing. What is the previous law or previous procedure that we discussed? The regular procedure. When there is a default, that you go through this process, money recovery action, right? If it is a mortgage property, then you go through the hypothecary action under Mortgage Act. So those are the two regular procedures available 200 years in this country. In 1990, what the legislature did, they introduced a new law to cater to the requirement of the business. So this, again, is a Special Provisions Act. So therefore, the regular money recovery action process and the hypothecary action is available. It is not repealed, it is not cancelled. So this is another process or procedure introduced by the legislature. Now, the purpose, I think we discussed last week, so we'll run through quickly. The purpose of the act is to provide a speedy procedure to recover debt. I have highlighted here through courts. So now what you have to see here is, what you have to understand here, it is, even though it is a speedy procedure, again this process is a court procedure. It's a court procedure, because when you compare this with the Parata process is not a court process, right? It's a process where you sell the mortgage property without going to courts or without going through court process. So the compare number 4 of 1990 Parata Act and 2 of 1990 Debt Recovery Act. The difference is, one is court process, the other one is not a court process. Then this act applies only to certain or named institutions only. Now you see, commercial banks, SMIB, NDB, NSB, BFCC, and registered finance companies can use this act and file action. So you see, only these institutions can use this act. So other institutions and individuals cannot file action under Debt Recovery Act, Special Provisions Act number 2 of 1990. So what is the procedure or the remedy available to them? So then they have to go through the regular procedure action, as we discussed before. So this is an important point. These are the preconditions that you have to fulfill before you filing action. So when you are answering a question, unless you write the qualifications or preconditions, that you will not be able to get full marks. Because sometimes when we ask explain the procedure, debt recovery special provisions procedure, they start from the LOD, right? The students, they start the answers saying send a letter of demand. So before that, you have to give an introduction to the procedure also, because you see there are so many or at least few preconditions are there. In these preconditions, are fulfilled, only that we can apply Act number 2 of 1990. So therefore, so it is again now you ask now the you want to discuss the answers or the how to write answers for the questions. So this is one thing that one clue that I give you. So don't write just when we ask the procedure. Don't just write the procedure, putting numbers 1, 2, 3, 4, and write the procedure. So before that, you have to explain and you have to give some introduction to the procedure. Then you write the procedure, because there are we allocate some marks for that introduction part. So then that's an important point. Now here, this legislature or this law is applicable only for the commercial banks, SMIB, NDB, NSB, DFCC, and registered finance companies. Then what is the procedure? Again, remember this is a court procedure, but it's not the regular court procedure. So in these cases, you see in money recovery action and hypothecary action, these are also court procedures, but they follow the regular procedure. In Sinhala, we call it Samanya Nadu Karya Patipati, regular court procedure. So that procedure takes about 3 to 4 years. If it is a hypothecary action, 4 to 5 years, get a result. So here in a debt recovery, under the Debt Recovery Act, it is also a court procedure, but the important part here is it is the procedures applied by the court is summary procedure. Summary. So these are very important points that you have to write in your answer. Even though it is a court procedure, court applies a summary procedure. This is in Sinhala we call this Lagu Karya Patipati. Summary, right? The regular procedure takes 5 years to get a result, final judgment. But when you follow the summary procedure, the difference here is you can get the final result within 1 year or maximum 1.5 years. So compared to regular procedure, where you get the final judgment in 5 years' time, the debt recovery summary procedure is a speedy procedure, because you can get the result, final result, within 1 year or maximum 1.5 years. So that is why we call it speedy. How it has become speedy? Because the court applies summary procedure. So then there is another precondition that we have to fulfill before we file action under debt recovery. So that is the granted loan amount, oh sorry, not the granted loan amount, dues, right? Dues, due amount, due debt, outstanding amount should be over 150,000. 150,000. Not 150,000, sorry, not 15 million or 150 million, 150,000, right? Then again, you may remember under the present law, if the debt is below 500,000, that is subject to a mediation board. That is subject to Mediation Board Act. So then you first of all you have to refer the matter to the mediation board, and if you can't settle there, then you have to obtain a non-settlement certificate from the mediation board. Then only you can file action. So same principle applies here. If you file for DR action for an amount below 500,000, then even though the due amount is 150, above 150,000, you just can't go out directly, can't file action. First, you have to refer to the mediation board, obtain the certificate of non-settlement, then file action. So, however, the cutoff limit or the condition is the dues should be over 150,000 rupees. Then there's another condition, that is the facility must be granted on an instrument or written agreement. So instrument mean instrument, example, a check or a promissory note, something like that, a negotiable instrument. So sometimes you see So we get a post-dated check and we grant them a loan. So if the customer is default, if it is a bullet payment, then what we do, we put the check into the account, and if the check get returned, so that is an instrument that we can use to file debt recovery action under 2 of 1990. So promissory note is another document. You may have seen this document. So it is a written document. It's a negotiable instrument again. So that if the customer has given a promissory note to the bank or the institution, to the lender, that based on the promissory note, complete stamped promissory note, we can file action against the customer under DR Act. So then, or if there is no instrument, that there has to be a written agreement. So without a written agreement, on verbal agreement or agreement by conduct, you can't file action under debt recovery law. So those are the conditions, preconditions to fulfill before we choose debt recovery procedure. So what are those? It has to be a lending institution mentioned in the Act, number one. Then the debt amount should be over 150,000. Number three, the loan has to be granted on a instrument or on a written agreement. Those three preconditions should be fulfilled before we choose debt recovery procedure. So any questions from here? Any questions? Okay, so then I'll go to the next one. Next we'll discuss the procedure under Debt Recovery Act 2 of 1990. So as we discussed before, the procedure is a court procedure. So that means that we have to file action in court of law, then get a judgment and execute the writ and seize the properties of the defendant and the guarantors and auction the property, get the money and settle the loan. This is the main procedure or main steps of a money recovery action. File action, go through a trial, get the judgment, execute the decree and seize the properties of the borrower and the guarantors, auction the property, get the money and recover the loan. So that is the summary of the procedure, right? So when we ask, there's another thing that I observed when we ask to write the procedure. That procedure, that the answers of the student does not cover the entire procedure. So the idea is you have to write the procedure from A to Z. How do you recover a loan through debt recovery process under Act number 2 of 1990? So some students, they have written up to the getting the judgment. So getting a judgment is not the recovery of loan. So you have to explain till the end, and how do you recover a loan through the procedure, through this procedure 2 of 1990. So then we'll see one by one, keeping that main steps of a litigation process. We will see how the summary procedure works. Now, regular procedure, you remember, again, if I repeat, we file action, we go through a trial, get a judgment, execute the decree by seizing the properties, auction the properties, receive money, and settle loan. So that is those are the main step of a regular action. Now, keep that in your mind. We'll see what is the procedure under 2 of 1990. Number one, I have not mentioned here, but number one should be, we have to send a letter of demand. in a normal case also we regular action. First thing we do is we send a letter of demand. So here also we send a letter of demand that you have to remember. Even though I have not mentioned here, that is the first step that we have to do. So when we are sending a letter of demand for a debt recovery action, right? Summary procedure action. One thing that you have to remember, under Debt Recovery Act number 2 of 1990, it is prohibited to claim penal interest or any penalty. So that is number one that you have to remember. Or in other words, when you are sending the letter of demand, you should not demand the penal interest or any additional charges as a penalty. So that is a very important point. So if you have calculated penal interest, or if you have calculated the penalty rate, so those that you have to reduce, and you can basically claim the capital outstanding and the interest, simple interest, without any penal interest or any additional interest. So that is very clearly mentioned in the Act, section 22. Section 22, as I remember, it is prohibited to claim that money. Money in the sense the default interest and the penal interest you can't demand. So then after sending the letter of demand, normally we give 14 days to the customer to settle the dues in total. But if he fail to comply to the letter of demand and pay the total dues, then we can file action under Debt Recovery Law of 2 of 1990. So then, what is the process? Here again, in a normal action, we file a legal action in courts. You know, when we are saying filing legal action, we have to file a plaint. If you compare this with the regular action, number one step is file legal action in courts, means that you file a plaint in courts. Plaint and the annexures we file together with the plaint. Then court issues summons. So when you compare this, right? First one, here also we file legal action by filing a plaint. Together with the plaint, there are important documents that you have to file under summary procedure. It's another difference from the regular action. So this is important. These are, you have to remember, right? Plaint, together with the plaint, we have to file an affidavit. An affidavit from a chief officer of the institution or the bank. That is a must, right? Plaint and affidavit from a principal officer of the bank or the institution mentioned in the Act. So it is very clear that you can't just put an affidavit of a junior staff member of the bank or the financial institution for this purpose. It has to be a principal officer. Principal officer, we normally what we do, we get an affidavit from a manager or above grade staff. So that is important. In some the companies, finance companies, even CEO or director sometimes sign the affidavit. So the requirement under the Act is it has to be a principal officer of the bank or the registered finance company mentioned there. So then that is number one document we have to annex to the plaint and the affidavit. Then number 3, plaint, affidavit, and the third document that we have to annex is the instrument. The instrument means the check or the check or the promissory note, or if there is no instrument, then we have to annex the written agreement, instrument or agreement that we have to annex. That is why we say the original agreement or the original instrument we have to annex to the plan. If there is no written agreement or instrument, then you see we can't go through this process. So the original instrument or the original written agreement has to file with the plain affidavit, and we have to annex that to that document there. Then apart from that, we have to provide all evidence, written evidence, to prove our case. What do you mean by that? So basically what we do here, or what we ask from the court, is that we say so and so obtained a loan and he didn't pay, he defaulted, and this he entered, when we are granting the loan, he entered into a written agreement, and thereafter he defaulted, and this much money is due to the bank, and provide a judgment to recover that money from the borrower. That is the story of your claim. So to prove that, you have to provide the evidence, written evidence. Now what are the documents that basically you have to annex? Now you know there is a restriction in the act, says that commercial banks and there are some other banks mentioned there, right? And also the registered finance companies can file action under debt recovery law. We take an example. We take a commercial bank, so right? We say the lender is a commercial bank. Now we are going to file action under debt recovery law. So the first thing that you mention in your plate is that you say that you are a commercial bank, and therefore you are entitled to file a debt recovery action under 2 of 1990. Now you have to provide the document to prove that you are a commercial bank, licensed commercial bank. For that, with the plan, with the affidavit, with the instrument, then you have to annex your license and your registration, the company registration documents, to prove that you are a bank, commercial bank, right? Now sometimes the bank officers, they sometimes ask, right? Okay, when you say commercial bank, everyone knows in Sri Lanka the commercial bank is a licensed commercial bank. So then why do you want the license and the registration document? Doesn't the judge knows that the commercial bank is a licensed commercial bank? So that often question that they ask. But remember, it is true that judge knows that the commercial bank is a licensed commercial bank in the country, but it is the burden of the plaintiff to prove it. So judges will give judgment based on the document available to them, and document available and provided by the plaintiff to them, and the evidence laid before them. So they can't go beyond that. Basically, they are not investigators and go and find evidence and give judgment. It is not their duty. So whatever the story that you say, that you have to prove if you are the plaintiff. So basically, number one, that you have to prove that you are a bank, then you provide those two documents. Then you say so and so is our customer. So the borrower is a customer. So then if you say he is a customer, so as we studied, that we know that the banker-customer relationship starts when he open an account. So basically, then he should be an account holder. So then for that, you have to prove he is a customer. How do you prove? Then you have to annex the mandate that he signed at the time of opening the account. So copy of the mandate you annex to the plaintiff and say he on such and such a date he gave a mandate and we opened an account. This is the number. Then he operated the account. So then thereafter you say on such and such a day that he requested for a facility, loan facility. So then you annex the loan application. Then you say that we offered him a loan. So then we annex the offer letter. Then again we say on such and such a date, the bank and the customer entered into a written agreement. That is a must under this process. So then you have to annex the original written agreement to the plan. So then after that we say on that agreement on such and such a date we granted him a loan and the loan was disbursed to this account. So then what you do, you take a account statement and you annex the account statement and you show on that day, particular day, the loan proceeds were granted or granted to the account. So then we say that he utilized the loan by withdrawing. So that also reflect on the account statement. Then thereafter you say that he didn't pay regularly and he defaulted. To prove that, you get loan repayment history and you show that how he has paid the money, how you have appropriated the deposits, how much you have recovered from the capital and interest, and how much is due. All those documents, the account statements that you have to certify, you mean the manager above staff has to certify under the provisions of the evidence ordinance. Your lawyers knows that, so they will ask to certify those documents. If they ask to certify the documents, this is another experience that I have experienced. The bank officers are reluctant to certify the documents. So they try to avoid that, but it is a legal requirement. Sometimes they ask why the lawyer can't or the legal officer can't certify the document. It is not possible under the law. It is the manager has to or above staff has to certify the documents, and they have to come and give evidence, not the lawyers. Lawyers can ask question from the witness. The lawyers can't give evidence on behalf of the witness. So therefore, remember those documents that you have to provide. Then you say that you send a letter of demand, you have to annex the letter of demand and the postal article. Likewise, all the original documents and agreements, instrument, together with the plaint and the affidavit, we have to annex to the plaint. So that is one thing that you have to remember, which is different from the regular action. In a regular action, when we are filing court in when we are filing a plaint in courts, we don't file all the documents in the first instance. So we produce those documents, the loan agreement and loan repayment history, account statement, and everything at the trial stage. Here, trial stage number 4, stage number 4. But when it comes to debt recovery action, the difference is we provide all those documents at the time of filing the action. In the first stage, we file together with the plaint, affidavit, instrument, and all other written evidence to prove the plaint. So you see, straight away we go into the 4th step on the regular action by when we are filing a case in under the debt recovery law. So that is why we say it is it's a summary procedure. Now, after filing, any questions from the first one? If you don't understand or if you need any clarification, please ask, because it is very important to understand the procedure.
Hello, sir.
Yes,
on the affidavit, what is mentioned on the affidavit normally, like?
Rangana, I can't hear your the question properly. Can
Hello.
you repeat it?
Can you hear me?
Yeah, Rangana. What is the question, Rangana?
What is mentioned on the affidavit normally on this case?
Okay. What do you mention in the affidavit? Right. Okay. Basically, what we do is we convert the plaint into the affidavit. Right. We convert the plaint in. Plaint is the story of plaint. In the plaint, we say this the story. what we have to say. We say that we are a bank. This is a customer. He obtained a loan. He defaulted, and this is the amount due. Likewise, we say our story. The same story we convert to an affidavit, but the affidavit is given in a personal capacity of the manager or above person, a principal officer of the bank. So apart from that, you say this amount is due to the bank lawfully, and I personally peruse the documents, and I assure that this amount is what have mentioned in the plain is correct, and the amount due is lawfully due to the bank. So that those are the words that we use, and those are that is the story that we mentioned in the affidavit. The affidavit is given in the personal capacity of an officer. So is that clear, Rangana?
Yes, thank you.
Right. Any other questions from the first stage?
Sir, in this procedure, after the first step, you straight go to the summons. No, once you file all the plain affidavits and all the required documentation, they straight away send the summons.
You mean under Debt Recovery 2 of 1990?
Yes.
No, actually no. There's no summons here, right? You see now when you go to this one, after filing, the court issue summons. You can see the screen, right?
Yes, sir.
Right. So this is regular action. In the regular action, you file first the plaint in courts, then the second step summons issue, then the defendant comes and file answer, then go for the trial. But when you go to this procedure, debt recovery procedure, there's no summons, right? Straight away we file all the documents that we provide at the trial in the regular action. At the first stage, in a summary procedure, we provide all these documents, and there's no summons. Summons won't come, right? Clear?
Yes.
Any other questions? Okay, so then we'll go to the second step. Now, after filing all these documents, now as I told you, there is no summons. Summons will not go to the defendant. The second step is support the case in court ex parte. That means the plaintiff and their lawyer has to go to court and support your case. Support your case ex parte. Ex parte means without the defendant or without the borrower. So you go to courts. The court will give a date to support once you file the action, and on that day, your lawyer and you, the representative of the bank, should go to courts, and that lawyer has to satisfy the judge that the documents are annexed to the plaint is genuine and without any alterations, and the story mentioned in the plaint is correct, and the amount due to the bank mentioned in the plaint is lawfully due to the bank. Those things that your lawyer has to prove to the judge. So judge can question the lawyer, basically that when you are supporting, the lawyer makes submission in courts, then the judge, if he or she wants a clarification, can ask questions from the lawyer, and also if the judge wants to more clarification, can even get evidence from the representative also. So that is called supporting the case in courts. Ex parte means without the other party. So you see, there's no summons, file action, then second step, you go to courts and you support the case. Defendant or the borrower still doesn't know that there is a case pending in courts against him. So then that is about the supporting of a case. Any clarification? Do you understand that part? Do you need any clarification? Second step? Okay, so I think it is clear then. So then after that, right? After that, if judge is satisfied with the submissions made by the lawyer, evidence given by the witness if necessary, and the documents provided with the plaint and the affidavit, then straight away judge will give a judgment. Judge will give a judgment, and it is not a final judgment. It is a intermediary judgment. It's not a final judgment, right? The judgment is known as well known as order nisi, NISI, right? Order nisi. It's a temporary judgment, not a final judgment, right? So you see, when you compare this with the summary procedure, in the summary procedure, we file action, serve summons, defendant come and file answer, then you go for a trial, then you get a judgment. Fifth step, right? To get a judgment in a regular procedure action, it takes at least 3 years time, right? 3 years time, 1 to 5 steps you have to follow. But when you come to this one, right, you file action, you support the case, then third one, you get a temporary judgment. Third step. Now this judgment, right, the temporary judgment you can get within 2 months time after filing the action, right? Most of the time within 1 month. If the workload is high in the court, then you at least within 2 months time you get a interim judgment, which is called decree nisi. So compared to the previous one, the regular procedure, you get a first judgment or the temporary judgment within 2 months time, right? This name that you have to remember, it is called order nisi, and it is a temporary judgment. Temporary judgment gives by the court after perusing the plaint, affidavit, instrument, and the evidence that you have provided, and after listening to the submissions made by your lawyer, and if necessary, the court can take evidence from the witness also. So you get a order nisi or a temporary judgment. Any questions from there? So it is now clear. Now you get a decree nisi, not the decree, order nisi. Then after that, the decree will be served to the defendant. So once you get the interim judgment, that interim judgment, that is decree nisi, will be served to the defendant. That is the first time that the defendant, the borrower and the guarantors get to know that there is a case like this filed against them. Basically, it's not like summons, right? Summons here, you see in the summary procedure, regular procedure, summons says there is a case filed against you, and if you have any answer to file, you come and file your answer on such and such a date. That is the notice of summons goes to the defendant in a regular action. But when it goes to summary procedure action, the decree nisi says a temporary judgment has given in favor of the bank against you. So if you have any reason to defend your case, that you have to come and get permission from courts to defend the case. So that is the difference between the summons and the decree nisi. Right? The first notice goes to the defendant in a regular summary procedure action is decree nisi. There's no summons. Right? What the decree nisi says, it says the court has given a judgment, temporary judgment, within bracket, decree nisi, or rather order nisi, has been given against you in favor of the bank. And if you have any valid reason to defend the case, you first have to get permission from courts, and then defend the case. That is the notice we send to the defendant and that is the borrower and the guarantors under debt recovery law. So any questions from there? Up to now, everything is clear. If you have any doubts, any clarification needed, can ask. We'll take one by one the steps, or otherwise it will confuse you. So far good, Rangana?
Can you the number 5 one? Can you once again clarify, sir?
Number five.
Yes.
Number 5, Rangana, we will discuss next. Now we
All
discuss about the number 4. Serve decree nisi. Is that clear? There's no summons, and we serve the decree to the defendant, right? So then thereafter, so what the defendant has to do? Defendant has to come to courts and just can't file answer, not like a regular action. Now, regular action, once the summons goes to the defendant comes and file answer. He has a right to do that. But here, it is different. When the decree is served to the defendant, the 5th step is defendant has to come to courts and has to seek permission from the courts to defend the case. So, without getting the permission of the courts, the defendant cannot file their answer in a summary procedure action. So when the defendant file papers seeking permission from courts, the courts will look into that documents and will see whether the defendant has a valid ground to defend the case or whether he's just trying to drag the matter by putting a bogus defense. So if court has the discretion to give permission or grant permission to the defendant to defend the case, or court can refuse the permission. So important point here is in the step 5, the defendant can't file their answer straight away. That the defendant has to get permission first from the courts, then only they can file their answer if they are given the permission by the courts. So that is number 5. Seek permission from courts. When they are seeking the permission, they have to seek permission by way of a petition and an affidavit. So defendant also has to file an affidavit together with their papers. They have to file petition, affidavit, and whatever the documents that they have to provide to courts, they have to annex those documents to the courts. Now, for example, we say the customer or the defendant, that is the borrower, says that he has paid the loan. We say, for example, just an example, the customer or the borrower says he has paid the total dues to the bank. Right? He says that I have fully paid the loan, but bank has not calculated or they have not accounted properly. So therefore, there is an error in the accounting. So if he can prove that, he can show that the deposit checks, or rather deposit slips, and if he can show the courts that he has paid the money properly, but the bank has misappropriated the money. There are instances like that, right? There can be mistakes done by the bank. The customer has given clear instructions to settle the loan. The bank has not settled the loan. Instead of that, the bank has recovered the OD when there is a clear instruction. So the customer has paid monthly installments without fail, but the bank has not appropriated the funds properly. So they have used the funds for some other purpose, to recover a credit card or to recover a overdraft without a security. So bank has utilized that money. So in a situation like that, if customer provide those documents and customer provide a valid ground to defend the courts, if court sees there is a is a chance that the defendant can win the case, or if court thinks that the defendant has a fair case to defend. So in a situation like that, court can grant permission. When court is granting permission, the court can grant unconditional permission. That means without any condition, the court provide the customer or the borrower to defend the case by filing papers and defend the case. Or court can grant permission, which is conditional permission. That means the court can say that the defendant has to file or has to deposit certain sum of money, and then only the court will provide permission. That is giving permission. Please excuse me for 2 minutes. Sorry. Okay. Any questions? Sorry. Any questions from there? Rangana, are you clear?
Yes, thank you.
Dilshani, Gavin,
Sir, can you explain that provision part again? The depositing money and that part.
Okay, the permission.
Yeah.
Right. Okay. Dilshani, it's like this. Now, when we say the defendant has to seek the permission, and court can grant permission after perusing the documents and the affidavit provided by the customer, the borrower. If court thinks the defendant has a good case to win, or the defendant has a good case to fight, then court can grant permission to the defendant. When granting permission, as per the provisions of the Act number 2 of 1990, court has a discretion. So the court can provide an unconditional permission. Unconditional permission means, so without any condition, the defendant is permitted to come and file their papers and defend the case. That is unconditional. So, or there is another way the court can give permission, that is called conditional permission. Conditional permission means court can ask the defendant, okay, you have admitted that you have obtained a loan, and you say you have paid a part of the loan, but you couldn't pay the full. But you say that the bank has not appropriated the funds correctly. So therefore, since you are admitting that some money is due to the bank, the court says deposit 25% of the loan amount as a security in courts, and then you file papers. That is called conditional permission. So court can say you provide a security, you deposit money, some money, we say 500,000 or sometimes 1 million, or depending on the case, it could be more than that. So likewise, the court can grant a conditional permission. That is, the court ordered the defendant to deposit some sum of money in courts, and then thereafter allow him to file papers and defend the case. Is that clear?
Yes, sir.
Right. Okay. So that is called conditional permission. Right. So up to now, up to this point, step 6, everything is clear for you? I hope that is clear, because now from here, there are two processes that we have to remember. That is why I asked. From here, you see, court can grant permission or court can refuse permission. Right? Court can refuse permission or court can grant permission. Right? First, we'll take we take this one, court grant permission. So if court grant permission, what will happen? Right? Then then what will happen? The defendant is allowed to file their objections. The defendant is allowed to file their objections. So then, if defendant file objection, then thereafter the matter will go for inquiry. Matter will go for inquiry. Now we compare with this one, right? Hypothetical, regular action. Defendant file answer, then the matter go for a trial. Go for a trial. You remember when we say the trial, trial means the plaintiff give evidence, defendant asks questions, plaintiff mark documents, then thereafter the defendant give evidence and defendant also allowed to file their documents. But here in the regular action, summary action, if permission is granted, the defendant has to file objections, right? Objections and their documents. Then after that, the matter will go for inquiry. So when you say inquiry, it is not a trial. Inquiry, the trial is, when we say in Sinhala we call it vibhagaya. Inquiry is called vimarshanaya, right? Inquiry is not a long process or long procedure compared to the trial. Inquiry is a shorter version of a trial. So inquiry, at the inquiry, the defendant in this matter, the defendant has to start the case and all the documents that he has to file with his objections. So then only those documents that you can provide as the evidence, and then thereafter the plaintiff can give his evidence. Then after that, what happened? If court think that the defendant's objection or the defendant's defense is not correct, then the court can convert this temporary judgment into a final judgment. That is called decree nisi made absolute. Right? The court can make this judgment, temporary judgment, step number 3, decree nisi or the order nisi. The court can convert that decree into the final judgment by making the decree nisi absolute. Right? So that is the procedure if court grant permission. If court refuse permission, that means the defendant is not allowed to file objection and there's no inquiry. So then straight away, then this decree nisi will be converted into a final judgment. Clear? Any questions from here? Rangana, are you okay?
Okay, sir.
So it is very clear now, right? So there are two procedures. If the permission is granted, defendant file objection, then go for inquiry. Then if court thinks the defendant's defense is not valid, then this temporary judgment will be converted to a final judgment, which is called decree nisi. So that is one procedure. If you go through this path, or the other procedure is if court refuse permission, that means the defendant is not given a chance to defend the case, then straight away the decree nisi will be converted into a decree absolute or the final judgment. So that is the procedure, and you get a final judgment in this matter within 1 year's time, that we can get the final judgment, or that is step number 9, final judgment. So after getting the final judgment, so what is the procedure? Then we have to execute the decree, and then execute the decree means through the fiscal that we can seize the properties. I think Rangana, you are right. Thank you. So then execute the decree and seize the properties of the defendant, the customer, and if there are guarantors, or the guarantors' properties also can be seized. Then auction the property and recover the loan. That is the procedure under 2 of 1990. So that's the entire procedure. So if you have any doubt, any clarification, if you need, you can ask from here. Okay, so no questions. Right, so when you are writing the procedure under 2 of 1990, first thing that you have to remember, don't jump into this and write these steps, right? It's not complete answer. Before that, you have to talk about the limitations and eligibility criteria under 2 of 1990. So this is the introduction part. This has to be there in your answer. So if these conditions are fulfilled, then you can go to the procedure under 2 of 1990. So the procedure starts with a letter of demand, which is not mentioned here. And then you have to follow the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 up to here. Then execution of decree. Further, you have to elaborate that what do you mean by executing a decree. So that means that the fiscal officer seize the properties of the borrower and the guarantors, then auction the properties, and from the money received from the auction can be utilized to settle the dues to the bank. So that is the debt recovery process under 2 of 1990.
So,
yes.
If say when the courts refuse the permission directly from step 6, it goes to step 9 and 10, no? 7 and 8 will be skipped, like
when the court refuse the permission.
Yeah.
Yes, if court refuse the permission, refuse means that the defendant is not permitted to file objection. There's no inquiry. Straight away, you go to step number 9, from 6 to 9. If grant permission, only 7 and 8 will be there. Clear?
Yes.
Yeah. So what you can do is you can put a arrow from here to here. If refuse permission, directly go to number 9. Right? Any other questions?
Sir?
Yes.
So in which court we are filing the case? Is it in a magistrate court or?
Very good question. Where we can file an action, in which courts? it is a district court. Remember, it is not the magistrate court. It is the district court that we have to file action. So when we say the district court, then in Sri Lanka we have a lot of district courts in every district. So then the question is where we are going to file, whether which district court that we are going to file. So it can be decided like this. If there is a written agreement, if you have entered the written agreement in a particular area, that we can file action in the particular area. For example, if you have entered into an agreement with the customer in Colombo, then you can file action in District Court of Colombo. Or if you want, you can file action in District Court where the defendant resides. That means we say we have granted the loan from Colombo branch, but the defendant lives in Galle. So then you can file action in District Court of Galle also. So that's is also possible. So anyway, the case has to be filed in District Court, not in any other court. Clear? Any other questions before I go to the next one? As I told you, this will be definitely there will be a question from here, right? And it will be about the procedures. You see, there are no judgments that you have to remember under 2 of 1990. Only the act and the procedure. That's all.
So, hello.
Yes.
In this procedure, there won't be any witnesses who have to appear in front of courts and give evidence. All the things will be based on documents, is it?
Not really. Now you see, if the defendant is given permission that he can file objection, and in this stage, you see, right? Sorry. Right here, number 8, there is an inquiry, right? At the inquiry, you can lead evidence. The defendant has to start the case, and he can give evidence. He has to give evidence in court, and he can produce whatever the documents that he provide. He has to provide here. And also, after the defendant's evidence, the plaintiff, that is the bank officers, also, if they want, they can give evidence. That evidence.
So what's the difference between the inquiry and the trial?
Okay, as I told you, the inquiry is a shorter version, right? Trial is a longer version. In the trial, here, now you see, if you take this one, in a trial, right? Trial, the plaintiff start the trial, and plaintiff can bring any number of witnesses as they wish. Defendant also said. So you can't restrict the number of witnesses that you are called. So that's why we say the normal money recovery action or the regular procedure action is lengthy, because when you file action under normal money recovery action, the defendant, the borrower, wants to drag the case. So what they can do is they can put unnecessary witnesses and drag the case for five years. So they can call the witnesses as they wish, and they can produce the documents as they wish, and they can drag the matter. So that the trial is a lengthy process where you can call any number of witnesses. But when it comes to inquiry is a shorter version. The number of witnesses are limited. You have to inform the court before how many witnesses that you are calling, and with the permission of the court only that you can call the witnesses. So basically, you are not the court will not bring unnecessary witnesses, because within a very short period, within 6 months time, basically the court wants to finish the inquiry. So in this inquiry, it is the defendant has to start the case, not the plaintiff. In a trial, plaintiff has to start the case. Here, the defendant has to start the case because already the judgment is given against the defendant. Judgment, a temporary judgment here has been given. So the defendant has to start the defense by giving evidence. The defendant can give evidence, that is the borrower, or if he wants, he can call the borrower, the guarantors with the permission of the court. That's all. Nobody else that he can bring unless the court is permitted. So sometimes court grant permission to bring expert evidence like accountants to show that the appropriation of funds is not correctly done by the bank. Likewise, with the permission of the court, you can bring witnesses, or otherwise only the defendant can give evidence, and it is very short version of a trial. That is a difference between the trial and the inquiry. Is that clear?
Yes.
Any other questions? Okay. So then I will go to the next procedure if you don't have questions from here. So the next procedure is the Parata procedure, the Parata process. This is a very important procedure for the bankers. Again, remember, again, as I told you, there will be a question. In fact, there will be a question from special debt recovery laws. So that question will have two parts. One is from 2 of 1990, and the other one is from 4 of 1990. So either you will get a question like that, a structured question with two parts from 2 of 1990 or 4 of 1990, or sometimes you can get a question from Parata procedure only and with a case study. So therefore, this anyway, from 2 of 1990 and 4 of 1990, there will be a question or questions, right? Okay, Parata procedure. The title of this act is Recovery of Loans by Banks Special Provisions Act number 4 of 1990. This you have to remember. The title of the act. Recovery of Loans by Banks within bracket Special Provisions Act number 4 of 1990. As I told you before, when you see Special Provisions Act, it means there is a procedure already there established, and this law is introduced instead of the apart from the other procedure. It is not a cancelling of a previous procedure and introducing a new law. This is an additional law introduced while the other procedure is existing. What is the procedure? What is the idea of this process? The idea of this procedure is to auction or sell the mortgage property and recover the loan. When there is a facility secured by a mortgage, movable or immovable mortgage, right? There is a procedure to recover that loan if the loan is defaulted. What is the procedure? This is the procedure. Hypothecary action, right? This is the regular mortgage bond recovery procedure. So if there is a mortgage, then you go and file hypothecary action in courts, then you register the dependent, then you file the declaration of lawyer, then serve summons, then the defendant comes and file answer. After that, the matter will be fixed for trial. Then we get a judgment. Then we execute the decree by auctioning the mortgage property, and we take the proceeds of the auction and recover the loans and dues. That is the procedure, hypothecary action procedure, how to sell a mortgage property. It's a court procedure through courts, through the fiscal. After getting a judgment, we can auction. So as I told you, this process takes about 4 to 5 years to get a final order or final result. So that's why we say it's a very slow process. So instead of that, while this process is there, in 1990s, the legislature introduced a new procedure. So this is called Act number 4 of 1990, Recovery of Loans Special Provisions Act. There is an important part here, that is recovery of loans by banks. That is very important. It says recovery of loans by banks. So recovery of loans by banks means this is applicable only to the banks, only to the banks. That is another thing that you have to remember. Act number 4 of 1990 is applicable only to the banks. These are, remember, the qualifications. These qualifications must be fulfilled when we decide whether it is whether we can apply 4 of 1990. So basically, in other words, Act number 4 of 1990 only applicable to the licensed commercial banks. Again, the Act number 4 of 1990, the Parata procedure is applicable only for the banks. It is not applicable to the financial institutions or any other institution. It's only for the banks. So that is a difference between 4 of 1990 and 2 of 1990. You remember, 2 of 1990, it applies to the banks and as well as other institutions mentioned in the Act. Here, it very clearly says it's applicable only to the bank. But remember, the Parata procedure has been given to the other banks also, which is not private commercial banks, but for example, state banks, Bank of Ceylon, People's Bank, they also have the Parata process. But People's Bank and the Bank of Ceylon and even DFCC, they have given this authority by their own acts, not under 4 of 1990. For example, Bank of Ceylon Act, Bank of Ceylon has been established by a Act, Parliament Act, that is called Bank of Ceylon Act. So the Bank of Ceylon Act has given powers to the Bank of Ceylon to execute Parity, and same procedure or same law, same thing has the law has been given the authority to the People's Bank under the People's Bank Act to go for Parity. But by introducing this 4 of 1990, the legislature gave the authority or the power to the commercial banks, the commercial licensed commercial banks, private banks, also the power of Parata to auction the property without going through the court procedure, that is hypothetical procedure. Before this act came into operation in 1990, all commercial banks went through the hypothetical action procedure to recover a loan which is secured by a mortgage bond. So now the situation is different. So the purpose of this act, an act to provide for a necessary recovery of loans granted by banks. Then the procedure, important thing that you have to remember, it is not a court procedure, it is a non-court procedure. So the bank, without going to court, going through the court procedure, can recover the loan through this process. Right. So then, any questions up to here?
So, is it applicable for these specialized banks like NSB and?
No, the specialized bank, they have not given the authority. That is another important thing that you have to remember. Unless it is not, they have given the authority under their own act. The banks, only for the commercial banks this has been given, right? Only the banks mentioned in the act only they can provide this. They have been provided this Parata procedure. Apart from that, the Bank of Ceylon, Bank of People's Bank, then DFCC, their own acts provide the Parata procedure. 4 of 1990 only applicable to the licensed commercial banks, not for the special banks. The special banks, they have given the Parata procedure under their own act. For example, SDB, they have given the Parata procedure under their own act, not under 4 of 1990. Clear?
Yes.
But the same procedure they have to follow. The procedure is the same, but the authority is given in a different acts. Clear? So then, shall I go through the procedure? Right. So this is the procedure under Parata under 4 of 1990. Right? As we see, the first step is we send the letter of demand. Right? We send the letter of demand. If customer is defaulted, then what we do, we send the letter of demand demanding the money. So the letter of demand here is little bit different from a normal letter of demand, because if the if the loan is secured by a property mortgage, we have to demand the money from the mortgage, on the mortgage, and we have to mention in the letter of demand, if we default the payment, if we fail to pay the total dues in 14 days time, that we are going to enforce the mortgage and sell the mortgage property and auction the and recover the loans. That we have to demand in our letter of demand. So that is first step, sending the letter of demand. Second step, so after sending the letter of demand, if the customer fails to pay the total amount we mentioned in the letter of demand, after that, under the Parata procedure, the director board of the bank can pass a resolution. The director board of the bank can pass a resolution. So again, remember, the passing of resolution is a duty of the director board of the bank. So by passing the resolution by the director board, the director board can appoint an auctioneer to auction the mortgage property. So the purpose of passing the resolution is to sell the mortgage property, right? For that purpose, the director board can appoint an auctioneer. Then there is another option provided in the Act 4 of 1990. What is that? There is a process, or there is an option where the director board can appoint a manager. Instead of an auctioneer, the director board can pass a resolution and appoint a manager. Now, what is the duty of the manager? Now we know, if the director board appoints an auctioneer, the auctioneer's duty is to auction the mortgage property and recover the loan. So that is his duty. But instead of appointing an auctioneer, if the board has decided to appoint a manager, what is the duty of the manager so appointed? Can someone answer to that question? Can someone guess the answer? Rangana, what do you think? Oh, Gavin, Dilshani.
To find a suitable buyer to the property or something like that.
To find the manager, you say manager's duty is to find a suitable buyer to sell the property.
Yes.
No, that is not correct. Now, auctioneer's duty is to auction the property and sell the property, right? That is his duty. Now, my question is, instead of an auctioneer, if the director board of the bank appoint a manager, what is the manager's duty? For what purpose is the manager appointed? Dilshani, Gavin, can you guess? Dilshani, can you guess? Why do you appoint a manager? No answer? Okay, think a situation like this, right? Now, we say the property, the mortgage property is, we say it's a factory. We say it's a garment factory, right? The garment factory is mortgaged to the bank and has obtained a loan, right? Now you have two options under 4 of 1990. Bank has two options. Bank can auction the property and sell the property and recover the loan. For that, we appoint the director board of the bank appoint an auctioneer. Auctioneer is the person who is authorized to auction the property. Remember, under the Parata Procedure, the property has to be auctioned by a public auction. You can't do a private transfer. So you have to anyway appoint an auctioneer to auction the property. That is one option available to the bank. There is another option available to the bank. So what is the purpose of this process? Purpose is to recover the loan. So then the bank can choose the second option, that is appoint a manager. So the manager will take over the operations of the factory and he will run the business, he will generate the income, and from the income, the manager will pay the bank loan. That is the second option available. So these are the two options available under the Parata Procedure. Now this second option is not common. So that is why it is not that much famous or familiar to us. We always think the Parata Procedure is there to sell the property and recover the loan. It is not so. There is another option, that is to manage the property and generate income and pay the loan. So for example, like that I gave, if the property is a factory, a garment factory, or we say a tea estate or tea factory, in a situation like that, instead of selling the property, auctioning the property, the bank can go for the second option, that is to income generate and pay the loan. So that is number 2. Any questions up to here? Any questions?
So if the board appoints a manager, still the ownership of the property will be with the customer while the bank is operating the business. Is it like that?
No, the good question. The ownership will not change. The ownership will remains with the customer, right? But the possession will be taken by the bank. So the customer can't run the business. He has to hand over the possessions to the manager. The manager will take over the business. He will run the business. He will take the income, and from the income he will settle the bank loan, and the balance money will be given to the the owner or the customer. So customer has the ownership, but the possession will be with the bank. So that is the difference. Clear?
Yes.
Any other questions? Okay, right. So since it is there are no questions, now we know about the appointing of manager. What is the purpose of appointing a manager? So we'll not go through that process there. Then we'll stop about the appointing of manager. Then we'll see and we'll discuss how we can auction the property under under the Parata under Parata process, right? So under Parata process, how we can auction. So after passing the resolution, the third step is notice of resolution. So this you have to remember. Third step is notice of resolution. Notice of resolution, we have to prepare a notice of resolution, and the notice shall be published in the Gazette and at least 3 daily newspapers in 3 languages. This is very important. These are mandatory provisions that we have to follow, right? The notice of resolution shall be published in the Gazette and at least 3 daily newspapers in Sinhala, English and Tamil languages. That is number 3. And also the notice of resolution, a copy of the notice of resolution shall be dispatched to the borrower. We have to send the notice of resolution to the borrower. Normally what we do, we send the notice of resolution by registered post. It is again a mandatory requirement. So 2 requirements are there. We have to publish the notice of resolution in the Gazette and the newspapers, and also we have to send the notice of resolution to the borrower under registered post. So that is number 4, step number 4. Up to the here, you see the steps number 1, 2, 3, 4 has to follow by the bank. So then number 5 is notice of sale. Now after sending the notice of resolution, we hand over the process to the auctioneer. Now the auctioneer has been appointed by a resolution. His name appears in the resolution, and thereafter we prepare the notice of resolution based on the resolution. So notice of resolution will be published in the Gazette and the newspapers, and a copy of the notice of resolution also will be sent to the borrower. Then we will hand over the process to the auctioneer. So up number 1, 2, 3, 4 steps are followed by the bank. Then number 5 is notice of sale. Notice of sale is a notice given by the auctioneer mentioning the date, time and the place of the sale shall be published in the Gazette, and copies of such shall be dispatched to the borrower and posted on or near the property to be sold within 14 days before the date of the auction. So that is number 5. So notice of sale, auctioneer has to prepare, right? So what are the information included in the notice of sale? It is about the auction. The date of the auction he has to mention. The time of the auction he has to mention. So all and the property details also has to be mentioned in the notice of sale. So after that, the notice of sale has to be published in the Gazette and the newspapers. Gazette and the newspapers. The notice of sale also has to be published. Not only that, a copy of the notice of sale also has to dispatch to the borrower. And also the notice of sale has to be published, has to be posted on or near the property. So we have to put the banners and posters, and the notice of sale has to be pasted on the property or near the property. Right? All these steps has to be taken before 14 days of the auction. This is again a mandatory requirement. Before 14 days, also we have to take these steps. Why we take these steps? All this time, the bank should give adequate time to the borrower to settle the loan and release the property. So that is why we send the notice of resolution informing the borrower the decision of the bank. So you basically send the notice of resolution to the borrower by the bank and say, look here, we have taken a decision and board has passed a resolution to auction your property. So therefore, if you want to settle the loan, you have time, you come and settle, and then we will release the property. That is the intention of sending of notice of resolution. Then after that, if he is still not paid the loan, then another notice will go. That is the notice of sale. This will be sent by the auctioneer. So auctioneer will send the notice to the borrower and say, look here, that I have given authority to auction your property. The property, the auction is scheduled on such and such a date on this time. So therefore, if you wish to settle, that you can settle before the auction. That is the intention of sending of notice of sale. So notice of sale, we have to send, the auctioneer has to send before 14 days, and he has to, before 14 days from the auction, and also he has to publish that in the Gazette and the newspapers before 14 days of the auction. So any questions from here? Okay, so then we'll go to the next step. Next step is upset price. Now everything is fixed for the auction. Now notice is given, customer has not settled the loan, so therefore now the auctioneer has to auction the property. So before we starting the auction, at the auction, the auctioneer has to start the auction from the minimum bidding price. So if you have seen an auction, so the auction, at the auction, auctioneer says the minimum bidding price is this, and then the bidders start bidding. So then how do you decide the minimum bidding price? The auctioneer can't decide that. So there is a provision in the act which says the director board of the bank has to decide the minimum auction price, which is called upset price. Upset price. Who decide that? The board of directors. Again, the bank. Bank has to decide the upset price, and the bank has to inform the auctioneer the minimum price, which is called upset price. The board has to fix an upset price below which the property shall not be sold to any person other than the bank. So at the auction, the bidding starts from the upset price. Auctioneer cannot sell the property below the upset price to any third party. Only the bank can purchase the property below the upset price if there are no other bidders at the auction. So when we are fixing the upset price, when the director board is fixing the upset price, there is no guideline given in the Act number 4 of 1990. But however, as per the guidelines given or the concerns raised by the central bank, when we are fixing the upset price, in fact, sorry, there's no guideline from the central bank also, but there are concerns from the central bank with regard to the selling price of the properties. So therefore, the banks are considering a few things. Basically, before we fixing the upset price, we take a valuation report from our panel valuer. So then we consider the market price of the property, for sale price of the property, and also the total dues of the customer. Based on that, the bank can decide the upset price, the director board can fix the upset price to the market value or the for sale value of the property as the upset price. So mainly or most commonly, it is the for sale value that we take as the upset price when we are fixing the upset price for the auction. So that is about the upset price. Any questions from there up to now?
So in deciding the upset price, the outstanding is not considered. No, we go by the property valuations. No.
No, as I told you, there are three things that we consider: market value, for sale value, and the outstanding amount. Right? Three things we consider basically because now what is the purpose of having the auction? Auction is to auction the property. Now, for example, we say the total dues of the bank. We'll take an example, right? We say the total dues to the bank is we say 7 million, and the property market value is 10 million, and the for sale value is 9 million, right? 7 million due, market value 10 million, for sale value is 9 million. So now you see, if we fix the upset price for 7 million, we can easily sell the property and we can recover our dues. But then the question is, the access, if after selling the property and after recovering the dues to the bank, if there is a residual, then excess money, that we have to return that money to the customer. So if we fix the upset price for 7 million, definitely then the customer will lose money and his property, because then it's a bargain to the purchaser and to the bank, but there will be a loss to the customer. So then the customer can challenge the sale. So therefore, for the safe side, we take the for sale value and we fix the upset price for the for sale value. Now take a situation like this. The property value is 8 million, for sale value is 7 million, the total dues is 9 million. In a situation like that, we can just forget about the market value and the for sale value, and we can fix the upset price for the total dues, that is 9 million. So since there is no clear guideline given in the Act 4 of 1990, we can choose either market value, either for sale value, or either total dues to the bank as the upset price. But normally, if the total dues are below the market value and also the for sale value, we don't keep the upset price for the dues, then we go for the for sale value and decide the upset price. If the total dues are over the market value and the for sale value, in a situation like that, the bank can decide to take the total dues as the upset price, but it is not mandatory. Is that clear?
Yes, sir. I think in this case, even though there aren't any legal instructions with regard to upset price, banks are in the practice of referring such selling price to central bank or something. I am not sure, but there's a procedure like that because central bank wants to make sure whether the customer is getting the right price for the property or something like that. I think banks are referring.
No, that is we take the central bank permission not at the time of setting the upset price, but if we acquire the property and then thereafter, if we are selling the property, if we are not supposed to sell the property below the market price. But if you want to sell the property below the market price and recover the loan, then we have to get the permission from the central bank to sell the property. That is after acquiring the property, but not at the option.
Yes, sir. Yes. Yes.
Clear?
Yes.
So any other questions up to now?
Sir, so if the property is sold above market above the outstanding value, the balance will be given to the customer.
Yes, we have to, but that is a mandatory requirement in the act. After settling the loan and the dues and the expenses, if there is excess money, that we have to return that money to the customer. We can't keep that money. That is not due to the bank. And if we take that money, that is undue enrichment. So the customer can sue the bank.
Okay. So what if it is sold like below the outstanding value because the market value is also low, and then
Yes.
it's sold below that? Then again, will the customer be liable to pay the balance that is due to the bank?
Correct. The customer is liable. There are two options to the bank. Bank can write off the balance and forget about the balance. That is one option. The other one is bank can, after selling the property, after settling all the dues to the of the customer, or not all, the part of the dues of the customer, for the rest of the money due from the customer, the bank can file a regular money recovery action in courts.
Oh. Thank you, sir.
Any other questions? Okay, so then we'll go to the next step. So after setting the upset price, then that upset price will be communicated to the auctioneer. Then the auctioneer at the auction will start the bidding at the minimum price, that is the upset price. Now at the auction, auctioneer start the auction, and it will be a public auction. The auctioneer will hold the auction on the property itself or nearby. So then at the auction, the bidders can bid at the auction. So then at the auction, if there are bidders, and the successful bidder, that means the highest bidder, can purchase the property. If there are no bidders, the bank officers can bid a nominal price and acquire the property. So the nominal price means the bank can say the bank will bid 1,000 rupees or sometimes 10,000 rupees as a nominal bid, and then the property will be acquired by the bank. That is only if there are no bidders. If there are bidders, the bank cannot do that. Then the property will go to the bidder. If there are no bidders, then it will be acquired by the bank. However, after the auction, the purchaser has to sign a document called condition of sale. That is an agreement between the auctioneer and the buyer. We say a third party has purchased the property, then the third party, the buyer, has to sign a condition of sale with the auctioneer. If bank officer purchased the property, that is acquired the property for a nominal price, again the bank officer has to sign the condition of sale with the auctioneer. So this is, you have to remember, the ninth step is condition of sale. After signing the condition, it's a notarially executed document. That means it's a document like a deed. Both parties, that is the auctioneer and the buyer, has to sign. Then after that, lawyer has to certify it and has to register at the land registry. So because it is a document related to a land. So then after signing the condition of sale, we say they will forget about the acquiring part. We say there is a buyer, and buyer at the auction, he signed the condition of sale. So after that, the buyer has to pay the consideration or the value of the property to the bank. So the buyer then has to deposit the money in the bank's account. And after he paid the total purchase price to the bank, then the bank director board will issue a title deed to the purchaser. That is called, the deed is called certificate of sale. The director board will issue a certificate of sale to the purchaser. Then thereafter, from the money that we receive from the auction, from the purchaser, we will recover the loan of the loan dues and also the expenses of the auction. So after that, after settling everything, if there is any excess money, that money that we have returned to the customer, we can't keep that money. That is, if there is a buyer. If there is no buyers, if there are no bidders, then the bank officer can bid a nominal fee or nominal price rather, nominal price, then that the bank can acquire the property. So after acquiring the property, the bank officer and the auctioneer has to sign the condition of sale. Then after that, the director board of the bank will issue a certificate of sale, giving the ownership of the property to the bank. That is called certificate of sale. Then the property will be vested temporary to the bank. Remember, the word I use is temporary because the bank cannot get the full ownership of the property by a Parata procedure, because it is not a method of acquiring properties. As the Act says, it's a debt recovery process. So therefore, bank cannot acquire the properties forever or can't get the full ownership of the property. It is only a temporary ownership that bank gets. So then after that, the bank has to find a purchaser during a reasonable time. So bank cannot keep the property for a long period. As soon as possible, the bank has to dispatch the property or sell the property to a purchaser, to a buyer. And again, the bank cannot sell the property below the market price. It has to be to the market price. If you are selling below the market price, the bank has to get permission from the central bank. And with the permission of the central bank, yes, we can sell below the market price. However, after selling the property, we have to recover the loans and dues and expenses, everything from that money. Then thereafter, if there are any excess money, again, we have to return to the customer. So as I explained you, if there are, after settling all the dues, if there is a balance from the customer due to the bank has two options. Bank can file action for the rest, the balance money, or bank can write off that loan, the balance outstanding, and close the file. So that is the Parata procedure steps of. There are 10 steps that you have to remember. So each and every step that you have to explain little when you are answering in your answer paper. So any questions up to now?
So one question on the upset price, if the owner of the land feels like whatever the price that the board of directors decided is not enough, can he contest it, or he has to agree to whatever the price the board of directors decided as the upset price?
Yeah, he can contest. He can go to courts and file action and get a enjoining order to prevent the bank by auctioning the property if we fix the upset price below the market price or the for sale value. But there has to be a rationale behind when we are fixing the upset price. That's why I told when we are fixing the upset price, we even though the guideline is not given in the Act, we have to follow a fair process. It has to be transparent. That is why we always take a valuation report, a fresh valuation report, and we consider the market price, and we consider the for sale value, and we consider the total dues. So if we fix the upset price, if we get a fresh valuation, and if we fix the upset price for the market value or the for sale value, that we can, in quotes, we can easily justify that, and we can get the permission from court for the auction. So otherwise, if we fix the upset price very below the market value or the for sale value, just because we want to recover the loan, the customer easily can challenge that, because it is not correct to do that, because we have to return whatever the money available or excess money to the customer after we settling our loan. So that is, here he can challenge the decision or the upset price if we have not followed a correct procedure. So is that clear?
Yes, sir, that's clear.
Any other questions?
So if there aren't any buyers, the bank will be mountain. There will be certificate of sale numbers. So is the bank able to utilize that property for a use of I mean for the use of the bank subsequently, or anyway they'll have to settle it?
Rangana, I think your question is whether the bank can use the acquired property for the use of the bank, right?
Yes, yes.
No, cannot. As I told you, the bank acquire the property. The bank, the ownership will be given to the bank for a short period of time. Then the act further says, within a reasonable time, the bank has to find a buyer and sell the property and settle the loan. And if there is any balance, that has to be returned to the customer. So therefore, the bank cannot use this property for the use of the bank. Basically, you can't open a branch and keep that property for you. So that is not permitted. It is prohibited unless the owner gives his consent. The owner can challenge that in court. So basically, no, you can't use the property for the use of the bank.
That is even if the bank cannot find a buyer after 5 years, still the bank can't use it. We'll have to keep it with us till we find a buyer. No?
Yeah, one thing, Rangana, now you can't keep a property for 5 years. It says within a reasonable time, as soon as possible, that we have to dispatch the property. So what we do is we have to immediately say publish advertisement, and if we can't find a buyer for the market price, then we have to go for the lesser value, lesser price. Then if we have purchasers, then we have to write to the central bank and get the permission and sell the property. Basically, you can't keep the property for a long period of time because it is not permitted under the act. So if it is already leased out property, of course, then we can take the lease rental, and we have to settle the loan from the lease rental. But again, we can't use the property for our use. It is not possible under the act. Is that clear?
Yes, but in practical scenario, in our cases, there are certain properties which are impossible to dispose due to certain issues like road access and other stuff. In that instances, even the bank is compelled to keep them. No?
Yeah, I know. That is the practical problems that we face, because Rangana, what you said is correct. Now, even though we say the access that we have to find a buyer within a short period of time, it is not easy. Now, I know that there are situations where the banks keep the property more than 5-10 years sometimes, just not because that they want to keep the property. There are a lot of issues. The customer can file action against the bank, then the matter will drag for years and years. Because of that, the bank can't find the seller. there can be occupants that you have to eject. They don't go when they don't give the possession, then you have to file action against them to eject them. Likewise, there can be many legal barriers that you can't sell the property. So in such cases you are excused. But if there are no legal barriers and if you can find a buyer, then you can't keep the property. Then the customer can challenge if you keep the property without selling, without reselling and settling his loan. Because if you keep the property without selling, the interest will get accumulated. The customer then will lose his money, and he will lose the value of the property also. So that is yes, what you said is correct. Even though it says that we have to sell the property quickly, it is not possible, it is not practical due to various reasons. But then, of course, you are excused. Otherwise, we can't use the property for our benefit, for the benefit of the bank. I think that is clear, Rangana?
Yes, thank you.
Right. Any other questions up to here? The process? Okay, so then the next that we are going to discuss about the restrictions on the Parata procedure. We'll have a 10 minutes break. Now it's 10 to 11. We'll meet at 11 o'clock. Then we discuss about the restrictions and the cases on Parata procedure. Right. Okay, we'll start. So we are going to start the limitation or restrictions on the Parata the procedure. So now, as we know, Act number 4 of 1990 has been given the authority to the banks, especially to the licensed commercial banks, to invoke the Parata procedure to auction the mortgage property and recover the loans dues. That when this act came into operation in 1990, basically there were no restrictions on the procedure. But however, later on, by introducing amendments to the act and by some decided cases, there are some restrictions now enforced or introduced to the Parata process. So we have to discuss and we have to understand those restrictions also, because those are certain things or the certain limitations that we have to consider before we decide whether the bank can go for Parata, or whether we have to go for a hypothetical action to auction the properties. That we have to decide based on the facts of the each and every case. So therefore, these restrictions or limitations are also important. So as I told you, there are there's a restrictions, there's a limitations introduced to the 4 of 1990 Act by an amendment made in 2011. So you see, in 2011, the legislature amended the previous Act number 4 of 1990. That is amendment number 1 of 2011 and amendment number 19 of 2011. These two that you have to remember, these amendments you have to read together with the main Act number 4 of 1990. Act. It's easy to remember. Both amendments came into operation in 2011 after 11 years of the main Act. That is Act number 1 of 2011 and Act number 19 of 2011. So Act number 19 of 2011, Amendment number 19 of 2011 came into or introduced on the same year 2011 because there was a confusion after the Amendment number 1 of 2011. To clarify the Amendment number 1 of 2011, the Amendment number 19 of 2011 was introduced. So that's what happened. So what is this restriction? Now, in the initial act, that is Act number 4 of 1990, there was no restriction. There's no financial limit. So financial restriction with regard to the Parata process. If I explain with an example, irrespective of the value of the mortgage bond, or irrespective of the outstanding of the mortgage, outstanding of the loan, the bank could go for Parata if the property is was given as a security or mortgage for the loan facility. For example, we say customer obtain a loan of 10 million and mortgage a property. We say the market value is 10 million and property mortgage. Now it is a facility secured by a mortgage property. So now after 5 years time, the customer has paid the loan some installments and has defaulted now. We say the total outstanding today is 2 million. So major portion of the loan has been paid. 8 million he has paid or more. Now the outstanding is only 2 million. So still before 2011, the amendments, the bank could auction the property under the 4 of 1990 because there was no financial restrictions. So bank can auction the property and bank can recover 2 million and the balance bank has to return to the customer. So that was the situation before 2011. However, in 2011, the legislature introduced this amendment. So the legislature thought that is unfair. If that power is given to the bank, it is unfair to the customers. If the major portion of the loan is paid, then the bank should not go for Parata. In a situation like that, the bank should go for hypothecary action or should go for other options without going for Parata. That was one thinking of the legislature. And at the same time, because of the pressure at that time put by the minor parties like JVP, they thought that the Parata procedure or that number 4 of 1990 has given a very big power to the banks, and because of that power, the banks are auctioning the properties and it is not healthy for the small scale businessmen and housing loan customers. They lose their properties, their residential properties and business properties, and therefore it is not healthy for the business or the economic environment of the country. So therefore they propose there should be a the limitation, there should be a financial barrier, financial limitations or financial cap where you can apply 4 of 1990. So that's the rather Parata procedure. So then on that basis, this limitation was introduced. So the limitations is actually 5 million. So Amendment number 1 of 2011 says no action shall be initiated to recover of any loan in respect of the of which the default is made, where the amount of such loan is less than rupees 5 million. So this is the amendment. So as per this act or the amendment, it says if the loan amount is less than 5 million, the bank cannot go parate. So if bank cannot go parate, that means the bank has to go through the hypothecary action, mortgage bond action, and file legal action in courts and go through that process in state of parate. Now, this is the limitation introduced by the legislature in 2011 by amendment number 1. Now, there was a after introducing this, now the banks cannot auction the property if the loan amount is less than 5 million. Now, for example, we say the bank has granted a 4 million loan and you have got the mortgage bond, the value of the mortgage bond, the market value of the property is 6 million. We have mortgage for 4 million. The customer defaulted. Now, as per this amendment, after this amendment, bank cannot go parate. Then bank has to go for hypothecary action, that is mortgage bond action, and file legal action in court of law. So then this amendment came in 2011, number one of 2011. Now after this word is the wordings is there, when there was a confusion. Now when we say less, the bank cannot go for parate if where the amount of such loan is less than rupees 5 million, then there was a confusion whether it is talking about the total outstanding or whether it talk about the loan, granted loan amount. So because of that confusion, the legislature, to clarify that confusion, introduced or brought up another amendment, that is number 19 of 2011. So as per the amendment number 19 of 2011, it says if the granted loan amount is below 5 million, then the bank cannot go for parate. That means if you have granted 4 million facility, then even though the outstanding is now we say with the interest is over 5 million, the bank cannot go parate. In other words, if we have granted a loan 6 million and the total outstanding is 4 million today, as per this amendment, still we can go parate. So then the limitation says granted loan amount is less than 5 million rupees, then the bank cannot go parate. That is as per the amendment number 1 of 2011 and number 19 of 2011. Any questions, any clarifications you need, you can ask. Is that clear, Rangana?
If the granted amount is above 5 million and the present outstanding is less than 5 million, what is this?
Okay. If the granted loan amount is over 5 million, that means the loan amount is over 5 million and the present outstanding is less than 5 million. That is your answer question, no, Rangana? Right. Okay. So now, as per this, right, as per this amendment, we can go parate, right? But listen very carefully, right? I say as per this amendment, we can go parate, right? So what we did, actually, that's what we did in before 2011. Now you see the law has developed, right? Over a period of time, law has developed. Initially, what happened in 2019 when the legislature introduced this law, irrespective of the amount of the loan granted and irrespective of the loan amount due, the banks went parate when the loan is defaulted. Then thereafter law change or law developed. In 2011, they put a restriction which says if the loan amount is below 5 million, then the bank cannot go parate. So that was cleared by another amendment, that is number 19, which says if the granted loan amount is below 5 million, then you can't go parate. In other words, if the granted loan amount is higher than 5 million, then bank can go parate. So that was the law. So So then what happened? For example, we say we have granted a loan of 6 million and the customer is defaulted now after 2 years. The outstanding amount is we say 2 million or 3 million today. So then the bank can go Parati. Legally, bank has a right to do that. Now again, we say the customer has granted the loan of 6 million and he has paid 5 years, and now the total outstanding is only 500,000. Can we go Parate? So as per this case, this amendment, yes, it is very clear because the granted loan amount is over 5 million. So due amount is not considered here. So therefore, bank can go Parate. So that is as per the amendment number 1 and 19 of 2011. However, then thereafter in 2017, a judgment given in the Sumudu Sanjeevani Nanayakar versus HNB. This matter, the same scenario what Rangana asked, was challenged in court of law. The customer argued in a situation like that, it is unfair if bank allowed to go for Parati. For example, we'll take the same example. Bank has granted the 6 million loan. Customer has paid 4 years or 5 years. Now the total outstanding is, we say, 500,000 only. The bank can go Parati. So in a situation like that, this customer argued it is unfair, and it is not the intention of the legislature. By intention of the legislature, when they give this power to the banks. So it was decided in this case, granted loan amount and the balance outstanding both has to be over 5 million if we go Parate. So now the law has changed by this judgment. Now it is not only the granted loan amount, and the amount due to the bank also has to be over 5 million. In as per this judgment, if the loan amount is 6 million and the today's outstanding is 4 million, then the bank cannot go Parati. But if the loan amount is 7 million and the total outstanding is today 5.5 million, so then that means the loan outstanding, granted loan amount and the total dues both are over 5 million. So therefore, we can go Parate as per the Sumudu Sanjeevani Nanayakar versus HNB case. Is that clear?
Yes, and the balance due is defined as the capital balance, no, not the interest not with the interest, I suppose.
As per this judgment, it says when you are saying the total dues to the bank, when you are calculating the dues, you should not add the interest component also. That is a part of the judgment. When you are calculating the capital outstanding must be over 5 million. So that is another part mentioned in the Sumudu Sanjeevani Nanayakara matter. Is that clear for the others?
Yes, sir.
Dilshani, Jamin, what do you think? You are clear with that restrictions?
Yes, sir, it's clear.
Yes, sir, it's clear.
Okay, right. So then we'll go to the next one. This is one limitation, and the next one is this: third-party property mortgages. Third-party property mortgages. That is decided in Chellayya Ramachandran versus some HNB matter. Special again. Important case when it comes to Parate. You can't write any clear or full answer without mentioning these cases. Chellayya Ramachandran versus HNB. What happened in this matter? Now, in this matter, Chellayya Ramachandran was the owner of the property, and he mortgaged the property to obtain a loan for a company. So, company there was a company that was a construction company. They constructed apartments and sold the apartments. So that was their business. Mr. Chellayya Ramachandran, who is the owner of the property, mortgaged the property to obtain a loan facility to the company. So then the company defaulted the payment and H&B went for Parata auction. So when when they went for auction, Mr. Chellayya Ramachandran went to court against the bank. And his argument was that as per the Act number 4 of 1990, the banks are permitted to auction the properties, mortgage properties, if those properties are first party mortgages. In other words, if the property is owned by the customer, the borrower himself. If it is not, if it is a third party mortgage, that means if a person, the person who owns the property is not the owner of the property. So in a situation like that, the bank has no right to auction the property under Parata. So in a situation like that, they argued the bank has to go for hypothecary action procedure. So then it went up to the Supreme Court. At the Supreme Court, it was held as per the wordings in the Act number 4 of 1990. The legislature's intention was to give this Parata auction authority to the banks only for the first party mortgages, because and as per this act, the third party mortgage properties cannot be auctioned under the Parata procedure. That was decided in Chellayya Ramachandran matter. Is that clear? So now there are two limitations by these that is Act number Amendment number 1 and 19 of 2011. By that, the financial restrictions was introduced, 5 million restriction, and by this judgment, Chellayya Ramachandran, there was another limitation introduced by Court of Law. That means third-party properties are not subject to Parata limitations. So those are two limitations introduced by the legislature and the courts. And thereafter, and again, have to remember Sumudhu Sanjeevani Nanayakara versus H&B matter, which is also relevant to the 5 million threshold, which says that when you are calculating the 5 million, the total outstanding means the granted loan amount, and also the dues also has to be over 5 million. And also when you are calculating the dues to the bank, it has to be the capital outstanding has to be over 5 million. You can't add the interest and say it is over 5 million. So that is Sumudhu Sanjeevani Nanayakara judgment. Then Chellayya Ramachandran judgment says third party properties are not subject to the mortgages. So not subject to the Parata. The third party mortgages are not subject to Parata. So therefore, you have to go for hypothecary action to sell the property. So then that is the law. That was the law actually. In fact, that is the law today. Even this Chellayya Ramachandran judgment has not changed yet. It is still in force when it comes to third-party mortgages. Is that clear to everyone? Rangana, are you clear?
Yes, sir. This is even the person is a director of that particular company. This applies as this.
Yes, it's a good question, Rangana, that I'm going to discuss next. For the time being, that we have to remember the law applicable and law established in the country is, if the property is a third-party mortgage property, that is not subject to the Parata procedure. When it comes to a third-party mortgage property, what is a third-party mortgage property? Next we are going to discuss that. When we say the third-party mortgage property, third party property means, third party mortgage means the borrower and the mortgagor are two different people, not the same. Borrower, that is the person who borrowed the money, and the mortgagor, that is the person who mortgaged the property, owner of the property, are two different people. So now we take a scenario like this. The company is a borrower. There is a company. The company is a borrower. So as we are aware, when we say a company is a legal entity. It has a different legal personality. It considered as a person, right? So then the borrower is a one person. Then we say one director of the company who owns the property, whom he mortgaged the property to obtain a loan for the company. So then definitely by looking at this, the mortgagor is a director, and the director is separate from the company. Company is a one entity and one person, legal person, and the director is a natural person who is different from the company. So therefore, the mortgagor is a different person. So the borrower and the mortgagor are not the same. So therefore, on the face of these facts, it's very clear it's a third party mortgage. It's a third party mortgage. So bank cannot go parate. So as per Chellaiya Ramachandra judgment. So then there is another important judgment given in our Supreme Court, that is Samathapala Jayawardena versus HL. So this, again, when I say this, now don't mess up. By Samathapala Jayawardena judgment, the Supreme Court not has overruled the judgment of Chellaiya Ramachandran. So that something that you have to remember. Chellaiya Ramachandran judgment is still valid for today, which says third party mortgages are not subject to Parity. So that law has not changed yet. It may change one day, but still it is valid. Right? Samathapala Jayawardena judgment is a different judgment. So there is a misunderstanding among the bankers and even even the general public think that the Samathapala Jayawardena judgment has overruled the judgment of Chellaiya Ramachandran, which is not the case. It is not correct. It's a different judgment. What is Samathapala Jayawardena judgment? It is relevant to a third party mortgage. That is true, but it has not overruled the judgment of Chellaiya Ramachandran. In Samathapala Jayawardena matter, what happened? There is a business. There was a business which is a company carried out by the family members, father, mother, and the son. They were the directors of the company, father, mother, and the son. And father, who is the managing director and the main business, the main director of the company, who holds the majority of the shares, who runs the business, right? Mother and the son, they had shares. I couldn't remember exactly. Maybe one share each, and they are also directors. They were also directors of the company. However, the business was run by the father, who is a major shareholder. 98% shares were owned by him, and he was the managing director, and he ran the business. Now, when you looked at the facts of the case, the company is there. The company is a legal entity, separate legal entity, which is recognized as a person under the law of the country, right? So it is the company is different from the directors. Directors are individual natural persons. They have different personality under the law. The company has a different personality. This company obtained a loan. company obtained a loan. Mr. Samathapala Jayawardena had a property. He was the owner, and he mortgaged the property to obtain a loan from the bank on behalf of the company. Now, the facts are similar to Chellayya Ramchandran matter. Right? Company borrowed the money. One director mortgaged the property. Now the company defaulted and HNB went for auction, the property. HNB went for auction. Mr. Samathapala Jayawardena, he went to courts. He went to courts and he argued that as per the Chellayya Ramachandran judgment, the bank has no right to auction the property of a third-party mortgage, of a third-party mortgagor. So the company is a different entity. The mortgagor, who is a director of the company, is a natural person who has a different personality. So this is clearly a third-party mortgage. Hence, the bank cannot go for Parati. That was their argument. So then, interesting thing happened. There is an English case called Salmon and Salmon. In this matter, the court, the English courts, there is a principle called lifting of corporate veil. Lifting of corporate veil means the the veil that you put in the bride's face or in the bride's the face to cover her face. So when you lift the veil, you can see the face, actual face, real face of the bride. So until such time, when the veil is there, you can't see who is behind the veil. So then, in this case, Salmon and Salmon, the court decided the court has the authority or court has the power to lift the corporate veil and see who is actually running the business, who is covered under the corporate veil. So by looking at that, by lifting the corporate veil, the court can decide who is liable for the transaction. So likewise, in this Samathapala Jayawardena matter, the Supreme Court of the country followed the rule of Salmon and Salmon case and lifted the corporate veil and observed that even though there are 3 directors in the company, the other 2 directors are only nominal directors. They hold only 1 share each. The main person behind the corporate veil or main person who ran the business is Mr. Samathapala Jayawardena. So he owns the property. He mortgaged the property and the company obtained the loan. So it was decided, the court was decided, the company and Mr. Samathapala Jayawardena are, though it is technically 2 different people, actually it is not different because it is Mr. Samathapala is the person who ran the business, who get the benefit of the business and who got the benefit of the loan. So therefore, it was decided this scenario, in a scenario like this, the court can lift the corporate veil and decide that the director who mortgaged the property is liable for the loan dues. So therefore, such a situation, such a third-party property can be auctioned under Parity. So that is a new development in law in Samathapala Jayawardena matter. I am telling you again, by Samathapala judgment, the court has not overruled the Chellayya Ramachandran judgment. So Chellayya Ramachandran judgment still valid. Samathapala Jayawardena is another different judgment where the court said the bank can auction third-party mortgages or mortgage properties in certain situations where you can show that by lifting the corporate veil, if you can show the director who has mortgaged the property is the person who is run the business and who has got the benefit of the loan. In a situation like that, it is subject to Parata. So any clarification if you need from Chellayya Ramachandran or Hamatapala Javardhana law principle judgments and the law principles introduced by Court of Law? Everything is clear? Rangana? Sure? You're okay with that?
Yes.
Right. So then the next judgment, a recent judgment, is Mudita Pereira versus DFCC Bank. In this matter, also it's with regard to a third-party property mortgages. It's based on the Samathapala Javardhana matter. Then the courts, the banks, started auctioning the property of the of a director's mortgages. So, for example, if a company has obtained a loan by mortgaging the director's property, based on the Samathapala Javardhana judgment, the banks started auctioning those properties if the loan is defaulted. In this scenario, the Mudita Pereira versus DFCC Bank matter, the company obtained the facility and Mr. Mudita Pereira, who is a director, has mortgaged his property to obtain the loan. So then the DFCC went for Parata at the default, and Mr. Mudita Pereira filed action against the company, against the bank. So then it was decided in favor of Mr. Mudita Pereira, and it was decided unless the bank can show the benefit of the loan has been taken by the director mortgagor, the bank has no right to go for auction third-party mortgages properties under Parata procedure. So Chellayya Ramasanjan judgment is still valid. So therefore, the bank cannot go for Parata to sell third-party mortgage properties unless the bank can show the benefit of the loan has gone to the director who has mortgaged the property. So in this case, what happened? In the mortgage bond, there was a clause to say the benefit of the loan or the benefit of the loan cannot be given to the mortgage or director. So that something like that, something similar to that effect. There was a condition. So based on that condition, the plaintiff was able to convince the court the benefit of the loan has not been given to the mortgagor, and no benefit has basically taken by the mortgagor, even though he is a director of the company. He's just a director. He has not got any benefit from the loan given to the company. It's a company he has enjoyed the loan. So therefore, it is a third-party mortgage property. So therefore, the bank has no right to go for Parata procedure in a situation like that. So it was held in favor of Mr. Mudita Pereira and confirmed that when it is a third-party mortgage property, the bank cannot go for Parata. So that's about the Parata procedure. So any questions from the Parata procedure? Any questions?
So, in a situation where the property is owned by two people jointly and the loan is obtained in a sole name of one of the owners, will it be considered as third party?
Yes, that technically that is a third-party property, because now when we say the two people are jointly owning the property, That means each person is has a right for undivided half share of the property. So one person is obtaining a loan and mortgaging the entire land. So that means both are mortgaging undivided half share of the person who has not obtained the loan also now mortgage. So that for that portion he can claim that is a third party mortgage. So in a situation like that, what we basically the banks do, so they add the other party also as a co-borrower to the to the to the mortgage as a co-borrower. But that also can be challenged one day in court of law if that other party can show that he has not got any benefit out of the loan. So then it can be a big problem. So to overcome that situation, what we can suggest is we can ask both parties, both owners to open a joint account and mortgage the property. Then after that, the loan can be disbursed to the joint account. So then it shows that the both are borrowers and both have taken the loan and enjoyed the loan. So then we can overcome that situation. So otherwise, if it is a joint owned property and one is a borrower, the other one can claim his part of the of the property is not mortgaged to the bank as a first party mortgage, and it is a third party mortgage. So that's the answer for that. Is that clear?
Yes.
Okay. Any other questions from here? Okay, so if you don't have any questions, remember sometimes you can get a question, a case study. So then you have to decide. Basically, they will give us a scenario. Then they can ask what is the best recovery procedure to recover the debts. Though in that situation that you have to decide, you have to which debt recovery process is applicable, because after analyzing the facts only that you can decide what is the best recovery process that you can adopt in a situation like that. When you decide that, basically that you have to decide whether it is the regular procedure, whether it is a summary procedure, that is DR action, if it is a mortgage property, whether it's a hypothecary action or whether it's a Parata action that you take. So that you have to decide based on the facts given. When you are deciding, we'll say the Parata procedure. So remember the Parata procedure, when you are deciding 4 of 1990, there are restrictions. What are the restrictions? First one, the loan lender has to be a licensed commercial bank. Number one, because the act will not apply to the financial institutions and others. So therefore, the lender has to be a bank. Number one. Number two, the property has to be secured by a mortgage bond. Right? If there is no mortgage bond, then you can't use Parata procedure. Then there is a restriction under the amendment number 190. The granted loan amount has to be over 5 million. Right? Then there is a restriction in the Sumudu Sanjeevani Nanayakara matter. That is, as per that one, it says not only the granted amount, both the capital, the outstanding, and also the granted amount, both has to be over 5 million. So that is the restriction number 4. Restriction number 5, Chellaiya Ramachandran matter, which says third party mortgages cannot be auctioned. So then there is an exception case, Samathapali Jayawardena, when it is a director who has mortgaged the property. and there's another related matter, mudita perra matter. So those restrictions and exceptions that you have to remember. After analyzing everything, only that you can decide which is the most suitable procedure to recover. Now, if you can't go parate, if there is a mortgage, then you see there is another procedure available, that is a hypothecary action procedure, right? So in a scenario like that, you have to decide what is the best suitable method. Since you said it is better to discuss cases, I will I will discuss a small case with you, but I have not prepared a note for that. So I will give you certain figures and facts you can note down, and then thereafter we will discuss whether what is the best suitable mechanism to adapt to recover the debt. Can we do that? Are you ready? Rangana, Dilshani, Gavin? Shall we discuss?
Yes, sir. Sure.
Right. Okay. So we say there is a bank. Bank name is BCC. Right? It's a bank. It's a commercial bank, licensed commercial bank. Right? And there is a company. We say it's the company is ABC. Right? Company is ABC, and there are two directors in this company, Mr. Pereira and Mrs. Pereira. Right? Mr. Pereira has 70% of the shares of the company, and Mrs. Pereira owns 30% of the shares. This company obtained a loan from the bank. The loan amount is 7 million. Mrs. Pereira has a property. She mortgaged the property for 7 million. Company defaulted the loan. Today the outstanding is 6 million. Total outstanding 6 million. Capital outstanding 4 million. Interest 2 million. Clear? You got the details? Everyone? Gavin?
Yes, sir. Good.
Rangana? Dilshani?
Yes.
Right. Now, can you, someone will say, Rangana, can you say what is the best recovery process that we can adopt? And then you have to say why you say that is the procedure that we have to adopt.
Since this is a facility obtained against property, either the bank should go for parate or hypothetical action.
Okay.
And since the loan since the present capital outstanding is below 5 million. The bank won't be able to initiate Parata action since it is below 5 million capital outstanding. Therefore, the bank will have to move forward with the hypothetical action to recover their dues by realizing the mortgage.
So you propose, Rangana, the bank has to go for hypothetical action. Bank cannot go Parati action.
Yes.
Right. Thank you, Rangana. Then we'll go to Dilshani. Dilshani, are you there? Okay. Then Gavin.
So I would also say the same, because in Parate there's two restrictions, which is the grant should be above 5 million, and also the mortgage, like the third party property mortgages. So both of these in this scenario, like all these two restrictions are there. So I think the best would be the hypothetical action.
Rangana, do you agree with Gavin? Is this a third party mortgage?
Yes, this in addition to this limitation on this amount restriction, even if the amount is above 5 million, bank won't be able to go for Parata since it is a third party property which is mortgaged for the company.
Why do you say it is a third party mortgage, Gavin?
So because the company is the one which has taken the loan, right?
Yes.
But actually there's no direct connection with the company and the director who actually mortgages the property, even though like she is a director, but she just has 30%, so there's no direct influence that which proves that she has actually done this thing for her own purpose, right? So yeah, according to like the case studies that we have gone through, I think that it comes as a third party mortgage property.
So what is the case that you are referring to?
The Mutita Pereira versus DFCC, right?
Right. And the other case, Samathapala Jayawardena. Yes.
Yeah.
Now you see, right, each and every point that you decide, you have to back by either by the case law or by a statutory law. So otherwise, you will not get full marks. So your answer is correct, but how do you present the answer? How do you formulate the answer? How do you justify your answer is matters. Now you say we in this case, when they ask what is the best recovery process, now you see by looking at the facts given here, we have to decide whether it is hypothetical action or whether it is Parate action, right? So because there is a mortgage property, right? So first thing that we have to see, I said, when we are deciding whether we can go Parate. Now, instead of a bank, we say this is a financial institution. Then what is the situation? We can't go Parate, right? So the first hurdle here, BCC is a commercial bank. That is an important information given in the question. So you have to underline that when you are reading. BCC is a licensed commercial bank. So that means the Act number 2 of 1990 and as well as Act number 4 of 1990 both apply, right? And also hypothetical actions also apply can procedure also apply to the bank. So then that number important information given. Then the second line says ABC is a company. When we say ABC is a company, you know that means it's a different entity and different personality, right? Number two. Number three says Mr. Pereira and Mrs. Pereira are the directors of the company. So when you get that information, the cases like Jayawardena, Samathapala Jayawardena and Mudita Pereira should come to your mind. So then further says Mr. Pereira owns 70% of the shares and 30% owned by Mrs. Pereira. Then Mudita Pereira judgment and Samathapala Jayawardena and lifting of corporate veil should come to your mind, right? All these things in your answer should address. Otherwise, you will not get the full marks, right? Then the company has obtained a loan. The loan amount is 7 million. Once you read that, it is an important point, and then the amendments, two amendments, number 1 of 2011 and number 19 of 2011 should come to your mind. That you have to address in your answer, right? So then further it says that loan is defaulted, 6 million is outstanding, capital outstanding 4 million and interest 2 million. Once you read that, that is also important information given in the question. Immediately the case Sumudu Sanjeevani Nanayakara versus HNB should come to your mind. So this question covers everything basically. Parate A to Z and also hypothetical reaction. Based on this, you see, since you can see there are two things that you have to address. One, whether this is a third party property or not. If it is a third party property, you know, still the bank can go Parati as per the Samathapala Jayawardena judgment. So you have to see whether this comes under Samathapala Jayawardena judgment or whether this is coming under Mudita Pereira matter. So by looking at this information, you see Mr. Pereira is owned only 70% of the shares and Mrs. Pereira only 30% shares. And no evidence in this scenario is given that Mrs. Pereira has been involved in the business and has got the benefit of the loan. So therefore, we have to assume that it is Mrs. Pereira has not taken any benefit from the loan. So as per the Mudita Pereira judgment, then the bank cannot go Parati. So Samathapala Jayawardena judgment will not apply in this case. Then the second point, what is the limitation? The limitation is 5 million. But the loan outstanding is over 6 million. Can we go Parate? Now it says the capital outstanding is 4 million and the interest outstanding is 2 million. That's how the 6 million has accrued. So immediately the case Sumudu Sanjeevani Nanayakara versus HNB comes to our mind. So which says the total, when we say the total outstanding 5 million, when we are calculating, the interest outstanding portion cannot be considered. It has to be the outstanding capital amount should be over 5 million. So therefore, in this case, since the capital outstanding is 4 million, the bank cannot go Parate. So then we have justified our answer, our decision basically. The bank cannot go Parate because of those reasons. So that is a part of the answer. Then what is the procedure available? Now the available procedure, since there is a mortgage property, we have to auction the property and recover the loan. So then the available other option is go for hypothetical action, file action and go for a trial and auction the property and recover the loan. That is the answer for that question. Is that clear?
So in this case, the shareholding is say the Sumati Jayawardena versus HNB case was not So only based on the shareholding alone.
No, no, Rambana, we can't say we can't decide that only based on the shareholding, right? So that is a one important point that we have to consider. Like Samathapala Jayawardena matter, if the main director holds the most shares of the company, we can assume that he is the person who has run the business. But it is one of the facts that we have to consider, but it is not the sole fact that we can decide who has got the benefit. But it can be minor shareholder director who has got the benefit of the loan and who has mortgaged the property. In a situation like that, of course, then Samathapala Jayawardena matter applies and we can go Parata.
Okay.
Right. So others, Gavin, Rangana, Dilshani, are you clear now how to answer a question if you get a question like that?
Yes, sir, one small question. So in this scenario, the third party property mortgages, so do we have to mention all these three case studies, like even the Shellaya Ramachandran, just to get a small idea of it, or is it necessary?
Yes. Basically, you have to just remember, if you get a question from this area, if you get a full question, right, it carries 20 marks, right? It means a half an hour answer. That means at least 4 pages answer, right? So basically, that you have to explain everything. That means you don't have to write the Parata procedure. It is not necessary. Now here it is very clear now. Parata procedure, you don't want to write LOD, likewise send the LOD, likewise you don't want to mention unless they have asked. Sometimes you can get a question, first part they ask, write the Parata procedure. Then of course you have to write the Parata procedure, which gives 10 marks, right? Then the second part, they can give a question, a case study like this, and to elaborate the answer. In a situation like that, you know that now it is not full answer, you get only 10 marks, so then you have to reduce your answer. Anyway, if you get a question like this, you have to mention the Act number 4 of 1990, then you have to mention the 2 amendments, 1 and 19 of 2011, and then Chellaya Ramachandran, Samathapala Jayawardena, Mudita Perra, and Sumudu Sanjeevani Nanayaka. Those are the main cases applicable and main amendments applicable to this case. So unless you write and explain the legal principles there, you will not be able to fully elaborate your answer fully. When I say that, don't write the details of the cases. That is another mistake you do. Sometimes some students, when we say the Samathapala Jayawardena matter, they write the Samathapala Jayawardena matter, facts of the Samathapala Jayawardena matter. You won't get any marks. Only the judgment, the principle derived from the judgment is necessary. It is not necessary to write the judgment, the facts of the case again. It is well-known fact, the case, and it is not need not to repeat the facts again. Only the law principle is important. Clear? Gavin, are you clear?
Yes, sir. Yeah. Thank you.
Right. Okay. So then we have to. I have some matters today, so therefore, as I told you, I'm going to stop at this point. So next week we'll start with our next lessons that I have already shared these topics. Some important laws for the bankers, that is about the dormant accounts and abandoned properties and all. Then before that, we have to discuss about the types of accounts. Those two topics that we'll discuss on next week, next Sunday at 8:30. Okay, thank you very much for the participation today. So the notes are given. So you have to study, you have to do your own readings also. We'll meet next week, next Sunday. Thank you very much.